Live. Hi everyone, Shaya here. I'm one of the lawyers at the Family Law Project. Thank you for joining us today for our webinar, What to Do If Your Ex is Not Following Your Parenting Plan or Court Orders. Before I start, I can see we've got lots of people who have joined us already. We've had over 100 people join this webinar, which is pretty massive. I suspect it means there's a lot of people who are a little bit disheartened with the family law system and what they can do, in fact, about making sure everybody complies with parenting plans and complies with parenting orders. I could see on the registrations as well that we've got over 50% of people registered are actually service providers. So pop in the chat there where you're working, who you're from, introduce yourself to everybody. So we've got polls that are going to drop throughout as well. I'd be super keen for this to be as interactive as possible. So use the chat box, get in on it, chat to each other. The polls are going to drop throughout. We'll have some offers towards the end. And the way I'm going to talk during this, this meeting, this webinar today is very much, I'll be using terminology like you, the other parent, your ex-partner. So just keep that in mind. If you're a legal advisor or a service provider, just keep that in mind. That's how I'm going to talk today, because I'm mindful as well. A lot of people that watch back these replays on our YouTube channel are actually parents. So that's how I'm going to talk today. And of course, I'm going to say this is general information only and not legal advice. We've got Ilham Rubber here. She's a director at the Family Law Project. She's in the chat box. Thank you, Ilham, for joining and facilitating the chat box. And she'll be there to answer your questions. So, hi, let's get started. Oh, here we go. I want to apologise. This is me. This is me doing my best to put together a slide. I spent a few hours more than that actually, putting together these slides. When I went to convert them yesterday, they went a bit stupid. So that's my contact details there. I apologise for the photo, and the handout you get towards the end of this webinar is going to look a lot better. Okay, what we're going to cover today. Here's the brief overview. So I think we need to take a step back, and before we talk about what you can do if your ex-partner is breaching an order or a parenting plan, just look at how, in fact, you can formalise your parenting arrangements. So we're going to look at that. We're going to briefly talk about why do people breach these parenting plans? Why do they breach the orders? Then we'll get on to remedies, so what you can do if there is a breach. And then we're going to focus on how to stay out of court. And I think it looks like in the chat box, we've got lots of people from family dispute resolution practitioners. So you'll be well across the FDR mediation type options. And then what we're going to talk about is if you have to go to court, then what's the proper application? So is it a recovery application? And I can see Josh in the chat has already asked a question about that. Is it going to be a contravention application or an enforcement application? And then towards the end of the webinar, we will talk about what to do if you want to breach the orders or if your kids aren't wanting to go. And we hear that a lot, you know, the kids aren't wanting to go. What can I do? So let's get started. How can you formalise your parenting arrangements? So there's 3 ways. The first is a parenting plan, which a lot of service providers will be across. The second is what's called consent minutes of order. And that's, I'll go into that in more detail later. And then the third way is when you've got court proceedings on foot, you've got litigation, and you've got court orders made that way. So what is a parenting plan? This is a very open question because parenting, it depends. It depends on what the parents have actually set out, and it depends on what precedent's been used, if it's a DIY. If in the chat box, any people working in an FDR setting, if you've got precedent parenting plans that you use, just let us know, because I suspect there's a lot of different ones going around. We, for example, and Elham will pop in the chat the link to our, we've got an online course, Parenting After Separation, and in that course we have formulated a parenting plan. We spent hours putting it together. It's very long, but some people, they might just have a piece of paper, sets out very briefly what is agreed. It's written, signed and dated. That, in effect, will still be a parenting plan. It sets out the living arrangements for the kids, where they live, how much time they spend with you both. It sets out parental responsibility sometimes, so who makes those decisions. And as long as it's written, signed and dated, then that's going to be a parenting plan. But they're not legally binding, and that's really important to remember. So even if they're written, signed and dated, they're not going to be legally binding. That doesn't mean you can't do anything about it, okay? I'm not being a Debbie Downer. So let's look at the type of things that a parenting plan might cover. So things like communication. So I've just put this slide up in full view, just so it's a little bit easier to read, because there's a bit of writing on there. But you can see the type of things it covers are around communication. So how parents communicate with each other, how parents communicate with children. A parenting plan might set out where children go to school, what's going to happen if they become unwell. It might set out travel arrangements, so interstate, international travel perhaps. It probably will set out handover or changeover, depending what state you're in is the terminology. And that's where the change of the child, if I can put it that horrible way, takes place. And some parenting plans, and I'd like to say the good ones, will set out what you're going to do if you come to a loggerhead, if there's something that comes up that you don't agree on, or what's going to happen in the future in terms of reviewing the parenting plan. Not all parenting plans have that, some do. So that's what a parenting plan might cover, and I'll just make that large again for anyone that wants to see it. And then I just pause there and get on to what are consent minutes of order. So in short, consent minutes of order, it's going to set out similar types of things. So the living arrangements for the children, the spending time arrangements, holiday time, special occasions, what happens in emergencies, how parents communicate, all the things I said before. But the difference is consent minutes of order are set out in a drafted format that's approved by the family law courts, and it's submitted to the court in the proper format along with an application, and it goes to a registrar of the court, which is like a step down from a judge. And if they're satisfied that the agreement reached is in the best interest of the children, they'll put the court stamp or seal on it, and that has the effect of a legally binding order. So that's the big difference between consent minutes of order and a parenting plan, is that it's legally binding as per any other court order. So I'm just going to check. I'm just going to pause there. If I'm going too fast, please let me know. I do tend to speak quickly. I'm just jumping at the polls. We've got 31% service providers here, 38% parents, legal advisors 18%, and other is 12.5%. I don't know who the other is. I'm sorry, I didn't cover anything. The next poll question was, if you are a parent, so just jump on now, answer the poll if you haven't already. If you are a parent, have you personally experienced your ex-partner breaching a parenting plan or parenting order? Yes is 60, it's just gone up 70%. It's fluctuating a bit. 60 to 70% say yes, so I suspect that's why you're here. And then the next poll that's dropped already is, do you think there are adequate remedies in place? So everyone can answer this question. Do you think there's adequate remedies in place to deal with parents who breach parenting plans or parenting orders? 0% said yes, 70 odd percent said no, and 30% unsure. Alrighty, cool. That just helps me to know where everybody's at. So we've talked about what consent minutes of order are. We've talked about parenting plans. The next way to formalise parenting agreements are court orders. So court orders, much the same as consent minutes of order. They're made during litigation of the family court. And when I say family court, I'm talking Federal Circuit, Family Court of Australia. It's quite the mouthful, so I'll just say family court. Court orders can be made on what's called an interim basis, which is during the start or during proceedings before they're finalised. They're still legally binding. Or court orders can be made as final orders by consent of the parents at any time during the proceedings. They basically get to the point where they say, look, we now agree on the final agreements. Let's get this done. Let's get it out of court. Or in the alternate, you've gone to trial and you've got final orders made at trial by a judge. So they're the ways you can have court orders made. Doesn't really matter how you got there, how the orders are made, doesn't really matter. The thing to know is that there's an expectation of the court that there be compliance. They're legally binding orders, and as parents, you've got to take all reasonable steps to ensure that your kids are going, and you have to positively encourage your kids to go. Really important to know that those orders remain in place until there's been a subsequent agreement between parents, if there is, or a subsequent court order if you've gone back to court. So if you've got final orders or interim orders, there's an expectation that you both comply with them. So let's just really briefly recap on the ways to formalise parenting arrangements. And I know for your legal advisors there, this is really basic. I have put references as we've gone along. I've put references to the Family Law Act and other legal cases and so on. So for the legal advisors there, you can go off and do your thing, do your research. But I've just spoken today as though we're talking to parents who probably aren't across Section 60cc of the Family Law Act as you guys are. So I'll just pull up this last slide again, just summarising or recap the ways to formalise parenting arrangements. So you've got parenting plan, you've got the consent minutes of order, or you've got a court order made at any stage during the litigation. So it brings us to the next step the next thing to consider. What is a breach? What's a breach of a parenting plan? What's a breach of a court order? So this slide here, again, I'll enlarge for you a bit. This is examples of what a breach might be. So withholding kids, not returning them to their primary carer, not facilitating time. So you've got a parenting plan in place or orders in place that say, little Johnny goes to spend time with his dad and you're not enabling that to happen. You're not facilitating that. A breach might be not facilitating telephone calls or video calls between a parent and a child. Another example of a breach is not sharing information that the parenting plan or order sets out that you're meant to. So, for example, exchanging medical reports, updated educational details, and so on. And another example of a breach might be not communicating with the other parent as set out in the order or parenting plan. So there's a whole array of examples of potential breaches, and you can see there that they vary as well in their extreme. So you always need to keep in mind what the breach is and what you're going to do about it, because I would say there's quite a difference between withholding a child to being, say, 5 minutes late to facilitate a telephone call. Quite a bit of a difference. Why do people breach? This emoji, I use this emoji a lot. in my life generally. I don't know what that says about me. But why do people breach parenting plans and orders? This is a very complex question. Super keen to know in the chat. Come up with some ideas, pop it in the chat. Why do you reckon? Give us some examples of why. Okay, so Louisa says, because there's no real consequences handed down by the courts. Thank you, Louisa. What else we got? Give us some other reasons why you think parents might breach orders. It's a complex question, really is. Lillian says, breach because a child feels unsafe with the other parent. Yep. Elena says, because they are angry. Yep. To control the other parent's freedoms. Yep. No consequence. Yep. Previous domestic violence. Yep. To spite the other parent. Yep. False allegations. Yep. Roxanne, who's an expert in this area, Roxanne Nathan from Relationships Australia, South Australia, because kids are no longer wishing to transition between homes because of their grief and loss as parents. Yep. Yeah, all those examples to some extent have truth, and they're still coming, but just read the chat. Okay. This is what I've come up with. These are some reasons and thoughts that I've had. There's no ongoing management or monitoring of either a parenting plan, consent minutes of order, or court order. There's some exceptions to that. So, for example, sometimes there'll be a parenting plan in place and it will say that the parties are to go off in a year's time and do further mediation, for example. Sometimes there'll be a parenting coordinator appointed by the court when there's final orders made. It's a relatively new thing that we've seen. And it's a really interesting topic actually, parenting coordinators, their job is to, once your matter's done and dusted, if you've got any disputes down the track, they're to help you resolve the issues and to keep you out of court again. The problem is there's a cost involved, so that kind of precludes their service being accessible to a lot of people. And just pulling up my screen again, another reason that there might not be compliance is because the lack of police enforcement. So the police are only able to really assist where there's recovery orders made. And sometimes the police will step in and assist you when they're not meant to, okay? So sometimes I'll be speaking to a client, particularly if they're in a country town, and they'll say, look, mum's withheld little Johnny. He's meant to live with me. I've got court orders from a year ago that says he lives with me. She's withheld them. Sometimes, particularly the local cops, will go around and check on little Johnny and might be able to sweet talk mum into doing, complying with the orders. But the reality is that they're limited in what they're allowed to do. So they can do welfare checks, definitely. And if you've got concerns for kids' welfare and safety, definitely. But they are limited in what they can do unless the court makes a subsequent recovery order. Another reason that people breach parenting plans and orders is just the complexity, the emotional, physical abuse, mental health and safety concerns, which all of these things are what you guys have raised in the chat box, and I can see that more questions and comments are coming through there. Other reasons, family dynamics, welfare concerns. This next one is quite a big one actually, and it's the poor drafting or formulation of a parenting plan or a court order. So there was a recent study done last year, and in that study, they questioned parents. I'll have to get the link for you later, but they questioned parents who had a parenting plan made at an FDR, a family dispute resolution service, and it was only 50% of those people who'd gone through the mediation service actually had the parenting plan explained to them. And likewise, there was, I think it was a higher rate of about 90% of people who had lawyers for orders being made had not had court orders explained to them, which is really concerning. So that might be one of the reasons is the poor drafting or lack of understanding. Poor drafting examples is where there's really a lack of specific information. Other reasons might be child refusal, which we'll talk about a bit later, and also difficult or vindictive behaviour, which we've also discussed in the chat box there. So I'm just going to pause there just to make sure everybody is still in check, and I'm just going to check the questions as well. And so just a reminder, there is a question section there. So if you've got any questions, pop them in the question section. The chat box is going off, so I'm really going to struggle to answer all the questions there. Elham, perhaps you could help me there, and then I'll go to the question section afterwards. I want to just pause there, and we've spoken about why you think people might breach orders. One of the studies that I'd read in preparation for this webinar was by an organisation called ANROWS, A and for nearly ROWS, ANROWS, and that's the Australian National Research Organisation for Women's Safety. Okay, that's a mouthful. It's a government agency. They did a study in October 2022, October last year, to try and ascertain the reasons they thought why people might be breaching court orders. So they had access to over 300 family court files. They interviewed 11 judges. They interviewed over 100 lawyers, and they did a big review of what's called contravention applications. I found it very interesting. If you'd like the link to that, just email me. I'll send you the study. It's a couple hundred pages. But I'll put up this slide. This is what they've said here about breaching court orders for obviously parents who have previously been in litigation. And I'll let you read that yourself. I'll just take a sip of tea while you're doing that. But I think it's pretty self-explanatory. All right. So let's move on to the next topic, which is remedies. And what can you do if there's a breach of a parenting plan? So we'll talk breach of parenting plan first, and then we'll talk breach of court order, because there's a difference, and you'll see that. Here's the overview. What are your remedies if you breach a parenting plan? Negotiate yourself, family dispute resolution, lawyer-assisted negotiation, lawyer-assisted mediation, and last but not least is court, which of course is what you're wanting to avoid. So let's go through them in a little bit more detail. First of all, family dispute resolution. And we've got a lot of FDRPs here, which is those that don't know, family dispute resolution practitioner. They're the guys that facilitate and run these mediations. Can I get it in the chat box from FDRPs how often you reckon you're coming across families in your service who are concerned about this issue, concerned about breaching of orders and breaching of parenting plans? So what is FDR? It's a family dispute resolution. They can be community run or government run. So you've got services like Relationships Australia, you've got family relationship centres, Centrecare, for example. They're examples of government-run services, and also private services. And essentially what they're trying to do is assist parents to reach agreement about their children with a goal of probably a parenting plan. You can use these services if you've already got a parenting plan in place, but you've got concerns that other parents breaching that parenting plan. So it can be a really good idea if you've not used their service for a long time. So if the parenting plan's quite old, it might be really appropriate to link back either in with the same service that you did previously or a different service. There's also private service providers who you can get into quicker. So if you need names of those services, email me, I'll give them to you. They're going to cost more, okay, but you're going to get in quicker. So it really depends on your sense of urgency, but there's different options available to you. The other thing with FDR is you've also got they're all child focused. Okay, they're all child focused, but there's also services that are child inclusive. And I'd be really keen to hear in the chat box who here does child inclusive FDR. It's something I'm keen to do a bit of study on, actually, but it essentially involves ensuring kids are more involved in decision making about them. So they don't actually come to the FDR, to the mediation, but a practitioner will speak with them, a qualified person will speak to them before the parents come together and give them the feedback during the mediation around kids' views, kids' concerns, and so on. So that can be a really good idea as well if the age appropriate and if you've not yet tried that. So that's one of the first options available to you, particularly if your direct negotiation, if you've not been able to reach an agreement there. This is some of the FLP lawyers. So we assist clients regularly by either attending legal aid FDR, legal aid mediation, or private mediation. We do a lot of that as well, where we go with clients, ensure they're being represented well, and the aim is to talk through any breaches and to avoid any future breaches of parenting plans. The other thing we do quite a bit of is writing a letter to the other party who you say is in breach. And the aim of this type of correspondence is to keep your matter out of court. So we might say, for example, look, we act for such and such. We understand there's a parenting plan in place. We say this is the breach and this is how it should be remedied. And we wish to avoid court. However, we're instructed to initiate court proceedings if need be. Now, that might sound aggressive. That's not the intention. The intention is to encourage an agreement. Okay, that's one way to put it. Next option that might be available to you, and I would say this should always be the fallback position. Court should be a last resort. If you've got a parenting plan in place and it's no longer working or one party's just not following it, your last resort will be court. And in most matters, you're going to have to try to do the mediation anyway with the FDR service to show that you've made a genuine attempt to resolve the matter. Keep in mind, it's costly, it's stressful, it might take a couple of years. And just because you've got a parenting plan in place doesn't mean that if you go to court, the judge is going to make orders that mirror that. So you might end up with orders that you're not happy with. And also the other party, when they do their response, he or she can seek whatever orders they're wanting as well, which might differ from the parenting plan. So that's also a risk that you have if you do go to court, aside from it being very stressful. Okay. What I would say is focus on mediation. If you've tried a service and you didn't like it, for whatever reason, perhaps try another service. If also consider solicitor mediation if need be. But if you can stay out of court, that's generally going to be best for you and in the children's best interest as well. So I can see there's lots of chats going on. Just looking back here. Oh, yes. So we've got some service providers here that do child inclusive. Quite a lot, actually. Yeah, it's really interesting. And just looking at the polls, are you still listening? 100% said yes, but it's a bit of a moot question, isn't it? Because if people here are just doing their emails and not really listening, they probably didn't see the poll in the first place. So let's summarise for you what the remedies are for enforcing a parenting plan. Number one, direct negotiation with your ex-partner. Number two is mediation, FDR, whether it's a community-based service, private service, solicitor assisted, or doing it yourself, doesn't matter. Next option, legal advice with a letter to the other party to encourage agreement. Final, last resort, court. So that's the summary of the options available to you for a parenting plan. What do you do then if you've got court orders in place? So that's what we're going to move on to next, is if there's court orders in place. So the remedies for enforcing order, you'll see here number 1, 2, 3, 4 is exactly the same. You can see that. The main difference is number 5. So all those remedies I just spoke of, if there's a breach of a parenting order, they may all be remedies that are suitable for you. In addition to that, we're also going to talk about now recovery applications, enforcement applications, and contravention applications. So number 1, what's a recovery order? And I know Josh early on in the chat asked what forms to use. So recovery orders are usually, it depends, Josh. You might need to email me. It's usually just an initiating application. Sometimes it's an application in a proceeding, but it depends on your circumstances. It's always going to have an affidavit that outlines your concerns, outlines the reason that you're seeking a recovery order. And essentially what a recovery order is, or an application is you're asking the court to make an order for a child to be delivered up and returned, and or straight away for the Australian Federal Police to recover and return a child. So it's where a child's been removed or not returned. They're the circumstances where a recovery application might be appropriate, and it's a good example of where mediation or FDR might not be appropriate. Every matter is different, but oftentimes I'm concerned when I speak to a new client who's delayed everything by a couple of months because they've gone off to try mediation or link in with a service, when really they should have just gone straight for the recovery order. So if you've got concerns about children's safety and welfare, generally speaking, recovery order is what should happen. If you're the primary carer and there's no reason for the other parent to withhold or return a child, then generally speaking, recovery order is the way to go. But every matter is different. But you just need to be aware of this, because I do see it a lot. I see a lot of time lost, a lot of delay, because people think that they have to go off to do mediation first, where oftentimes it's not suitable. Often it is. I'm not meaning to speak generally, but that's the nature of family law. It's quite grey, because every family is different. Every situation is different. So we then go on to contravention or enforcement. So I asked ChatGPT. I asked a question. ChatGPT, what is the difference between a contravention application and an enforcement application in the Federal Circuit and Family Court of Australia? And please direct me to the sections of the Family Law Act that tells me the difference and what forms to fill. So it might or might not surprise you that ChatGPT was half accurate. And I may or may not have lost about 2 hours on that platform researching all sorts of things. After doing so, my advice to you would be, if you are not a lawyer, or even if you are a lawyer, do not rely on ChatGPT. Actually, just getting off topic, there was a podcast, the ABC Law Report last week, which some of you might have heard, and there was a lawyer in the States, and he had done written submissions based on all this case law and had come up with based on ChatGPT. Did anyone hear that? It was so funny, but he got caught out. It was so realistic. This lawyer believed these cases were true. He even asked ChatGPT, are these cases real? And the response was yes, but they weren't. And it was, that's it, Karina, fake precedents. It was interesting. I'd recommend that podcast to any legal advisors. Anyway, so let's disregard ChatGPT and let me tell you what a contravention application and an enforcement application is. So these are around where you've got court orders in place and they've been breached. If you go to court, do you consider a contravention application or do you do an enforcement application, if at all? The main overview here I've put up on the screen is you need to consider the result that you're wanting. So contravention applications are to enforce the order and to punish, and I've put there the division of the Act there for the legal advisors to look into. Whereas the next slide on enforcement applications, same goes, they're there to enforce orders. However, it's not used for a punishment. So that's the main difference between the two, is you're both there to enforce current orders. Contravention is more of a penalty as well, whereas enforcement is purely focused on enforcing the orders. Let's go into a bit of a deep dive. This would have to be my favourite slide, actually. So this is self-indulgent. This is me. This is close to 2 years ago now. I went snorkeling with the whale sharks in Ningaloo, Western Australia. One of the best things I've done in my life. Check this one out. You can see from this photo how small we were. It's the most incredible experience. And because I'm going into a deep dive, I use that as an excuse to be able to look at these pictures again. I think it's magnificent. Yeah, it's if I'd recommend it to anybody, it's probably, I would say it would be in the top 5 things I've done in my life. Probably about that. And anyway, let's get back on topic. Contravention applications are quasi-criminal. So they're partially criminal. And what that means is that there's sanctions that are sort of the sanctions that you'd see in criminal proceedings. So because they're quasi-criminal, you just need to be mindful of that. And you need to be able to show that there was an intentional failure of the other party to comply with the orders, and also they made no reasonable attempt to comply with orders. You have to be a party to the proceeding, and it might sound a bit silly to say that, but oftentimes you might be upset with a grandparent, for example, as opposed to someone who's a parent or a party to the proceedings. But if you're doing a contravention application, it needs to actually be a party to the proceedings. And it might sound straightforward to say that, but we do actually see that quite a bit, that people, because a lot of the people bringing these applications are self-represented litigants, so might be a little bit unsure around what they can or can't do. This is the other big one, and I spoke a bit earlier about the importance of drafting and making sure orders are really clear. With your contravention applications, there has to be what's called an operative order. And essentially what that means is that it's an order that you can clearly say was breached. So, for example, if, let's say there's a final order that says little Johnny spends time with dad as agreed between the parties. It's really difficult to prove there's a breach of that order because it's so unclear. Likewise, if you say the final orders say little Johnny is to spend time with mum every Saturday, and in mum's mind, that means she's going to have little Johnny all day, but dad's only sending little Johnny for 1 hour on a Saturday. So that's going to be really difficult for mum to say that there's a breach of the order because the operative order is so unclear. So I hope that makes sense. And the big thing here is reasonable excuse. So not only are you needing to show there's an intentional failure to breach the order, but also that there's no reasonable excuse. So an example of a reasonable excuse might be there's new welfare concerns, there's new safety concerns for the child that weren't there when the orders were made, and I had to withhold the children because there's fresh allegations of drug use in the other house, and care and protection in my state has been involved, and I'm really concerned about sending the kids there. That might be considered a reasonable excuse, as long as you're only withholding the children for as long as need be. So let's say then you get to a point where child protection says, oh, a week later, we're not concerned for kids' safety. That might be then when you get into some difficulty. Those matters are quite complex, but that's an example of what a reasonable excuse would be. It's really important not to be opportunistic. So in terms of sanctions, oops, sorry, so that slide's just a repeat of what we've said. Examples. Okay, I've just skipped ahead a few slides. So because, like I said, it's quasi-criminal. So you'll see here on the slide that the types of sanctions available to the judge to make range from make-up time, enforcing the order, having one or both parents attend a parenting program, a bond, a fine, community service, although that's not in every state. Okay, so for example, there's no agreement in South Australia for community service. Here's the big one, imprisonment. So the court has jurisdiction to imprison up to 12 months. Love to know in the chat box, do you think that's enough time? 12 months. I'm going to say that this is a last resort, and I've been practicing for over 20 years now. Only a couple of times, and not in my matters, thankfully, I've heard of judicial officers imprisoning people for contravention breaches. It's where there's extreme breaches and or persistent breaches, so, like ongoing breaches. It's rare, it doesn't happen very often, but you need to be mindful that it can happen. Here's more sanctions available to the court. They can vary the parenting orders, and even if a contravention breach is not found, the court can still vary the parenting orders. I've put beware there because they might be varied in a way that you're not happy with. So always be mindful of that. Even if you bring a contravention application, you might find that orders are being made that you don't actually really want and you don't agree with. Here's some more sanctions. The court can make cost orders against either party. And lawyers here, I've put the practice direction for you to look at. With the changes to the family law courts in September 21, we now see solicitors themselves having cost orders against them if their application or defence is without merit. So very important to be aware of that. So again, because it's quasi-criminal and the court can make some serious orders, the flow-on effect of that is that there's a really strict requirement around the process and drafting. And the other thing I'll just jump in and say here as well is that before you file a contravention application, you do have to attempt family dispute resolution or mediation. The usual exceptions apply. So the usual exceptions to not have to do mediation are things such as, family violence, child protection concerns, welfare concerns. With contravention applications, there's a further exception to be aware of, which I think is really important, particularly for legal advisors to know. If the orders have been made within 12 months, you can bypass that, okay? So oftentimes you don't want to waste time. And so if the order's been made within the past 12 months, you might be able to bypass that. I'll enlarge this slide for you. This is all about the national contravention list. And this was a list that was set up in September 2021 with the restructuring of the court. And it's a national contravention list that's run by judicial registrars. And all the applications now are just actually emailed through to a contravention registrar email address. And you'll see there in these dot points, it's an electronic list. So it basically means that the registrars hear the hearings by MS Teams or equivalent. The goal is to be efficient. to be cost effective, the first return date, which means the first hearing date, is meant to be within 14 days of filing. They like to do triage. So even if you don't have to do FDR mediation, they might send you off to do it. With your application, you need to include, attach the order that you say has been breached. You also need a supporting affidavit, and I'll just enlarge this because that affidavit is going to set out and detail the acts or omissions you say the other party's done, and it's got to set out the evidence as well why there's no reasonable excuse for the other party not to have complied with orders. The other important thing is you should also set out findings of previous breaches. So if you've previously had contravention orders, for example, and findings of breaches, super, super important you include that because that's one of the considerations the court makes with their sanctions, okay? If you've been served with a contravention application, really important to know that you do not have to file anything except for a notice of address for service. It may or may not be in your interest to draft an affidavit and file that, but definitely get legal advice before doing so. You're not legally required to. You get leave or permission from the court to do so, but hold off doing that until you have had some legal advice. In terms of the actual hearings, if you're the respondent, you must go to court. You might get a warrant for your arrest if you don't. At the first hearing, like I mentioned, they're going to sort of triage everything. They might send you off to mediation, FDR. They might send you off to a court-ordered mediation. They're always going to focus on what the best interests of the children are, and they might consider whether a child impact report is done by the court, by a family consultant, to help the court work out what's going on with the family. So that's always the final hearing. You never jump to the that's the interim hearings. You never jump straight to the final hearing. But with the final hearing, because it is quasi-criminal, each count of the breach that you say has happened is going to get put to the respondent, and they'll answer yes or no, guilty sort of thing, or not sort of thing, that's not a legal term. But they'll also say, yes, I admit the breach, however, I had a reasonable excuse, or I admit the breach, full stop, or no, I do not admit the breach. And they're the things that are dealt with at the final hearing. Interesting to know, a lot of matters don't even get to that point. I think it was two-thirds of contravention applications are dismissed or withdrawn prior to final hearing. So, and actually, I think contravention applications make up 8% of applications that are going through the court. So, yeah. And then next slide is around the burden of proof. I'll just make that larger for you. It's kind of talking about the standard of proof. So how certain the court needs to be to find the allegation is true or not. And the burden of proof, it's for the applicant to say that there's been a contravention. And then it's for the respondent to say that they had a reasonable excuse. And you can see here it's on the balance of probabilities. But if you're seeking orders which include things like imprisonment, bond, community service, that standard of proof is raised to a criminal level, which is beyond reasonable doubt, which is, you might find that more difficult to establish. All right, so if it's established, the court can make those orders we've spoken about before. It's always based on the best interest. And the court's also going to look at if there's been a serious disregard as well. So serious disregard might be, like I mentioned, previous breaches. Kidnapping is one, which I see a bit, unfortunately. Persistent disregard of orders. They're the sort of things that the court's going to look at. Most common outcome, oh, here we go. This is what I was saying before. 2/3 dismissed, withdrawn, discontinued, or struck out. The second most common outcome for contravention applications is a variation of the order. Bonds, very small. Fines, imprisonment, even smaller, as you can imagine. Probably no surprises there. Now, this next slide is incorrect. It's me again with my whale sharks. Instead of contravention application deep dive, it should say enforcement application deep dive, because that's what we're getting onto now. So keep your questions coming in the question section. I can see the handout has now dropped as well, which means I need to hurry up because we're getting towards the end. But yeah, if you've got any questions, just make sure you're putting them in the question section. Let's deep dive now into enforcement applications. So you're not seeking a punishment. The goal is to ensure a resumption of time, and also importantly, the goal is to ensure future compliance, because you don't want this to continue happening. Purpose here, whole purpose, ensure the compliance of orders. I've put a case law there for legal advisors playing along. The process is different from contravention applications. So as with contravention, there's no filing fee. You've got your application affidavit. It's not dealt with by that national list, but you'll see there in the rules that it needs to be dealt with quickly as well. A lot of self-reps do the enforcement applications themselves. Same goes, the court's going to look at sending you off to mediation or a parenting program. That's quite common. And you'll have your final hearing as well. So it's similarities in the process. Main difference in the application is one has got criminal sanctions, the other doesn't. So of course, in the enforcement proceedings, you're not going through that procedure of putting the count and, that burden of proof and so on is just not there. How's everyone going? We're getting into the last section. Is everyone going okay? I'm just going to check these polls while Right, so we're just going to go into now the final section, which is what to do when kids don't want to go anymore. I'm just looking at this poll. Do you think children, if you've not answered this yet, just jump on now quickly. Do you think children should be involved in all parenting plans and parenting orders that impact them? 15% said yes, 7% said no, 80%, I changed those percentages slightly, depends on age and maturity of child. I would agree that it depends on the age and maturity of child. That's my view. Do you think it should be up to the children if they no longer want to comply with a parenting plan or parenting order? 8% said yes. 92% said again, it depends on the child and the family circumstances. So kids don't want to go. What are you going to do? This is such a common question that we get. And I don't want this section to aggravate anyone who's experienced this themselves, because oftentimes my answer is going to be, it depends on your family situation. It depends on the child. It depends on the reasons. But let's get into it anyway. So kids don't want to go. What do? Well, if they're old enough, this is what you want to avoid. If they're old enough, they're going to vote with their feet. And I see that a lot, unfortunately. A lot of the work I do is representing children as an independent children's lawyer. If you've got kids getting to a certain age, they're going to vote with their feet. If it's a parenting plan or an order, it doesn't matter. If they don't want to go anymore and they want to spend weekends with their friends doing whatever they get up to these days, that's, it's a really difficult situation. This is the next myth that we hear all the time around what age can the kids decide. I'll enlarge this slide for you. 12 years is not the magic number. There's, I hear this all the time, and I wonder if it's because when I worked in the care and protection jurisdiction in New South Wales in the youth court or children's court, we were directly instructed by 12-year-olds or kids older than 12. So basically, we were subject to their instructions. And I wonder if that's where the confusion comes from in Australia. But there is there is no set age where the kids can make a decision. You need to look at their maturity, the reasons that they don't want to go, what's going on in that family dynamics. So each family is different. Is there a history of alienation, for example? Are there concerns about child protection and welfare concerns? And then there's going to be a difference again around whether there's a parenting plan or court orders around what age the kids can decide. So if there's a parenting plan in place, remember, it's not legally binding. If kids aren't wanting to go, then I would consider mediation, FDR, particularly child inclusive mediation for older children, because if kids are no longer wanting to go, don't you want to get their views around that and take that into consideration? Talking to the other parent around these issues if you can. I know that's very difficult where one parent's vindictive or there is alienation, but if you've got some sort of amicable relationship and that's an option, then use it. You need to encourage the kids to go. I've talked about that before. Even though a parenting plan is not binding, you should still encourage your children to go. If the kids aren't going and if you can't resolve it with your ex-partner, then you risk being served with documents and you run the risk of going to court, which is what everyone wants to avoid. So quite different then from kids not wanting to go for a parenting plan that's not legally enforceable to court orders. So this I've taken direct from the Family Court website. These two quotes here: you must take positive action. Positive action includes taking reasonable steps. You must positively encourage your children to comply with orders. You cannot merely be passive. So unfortunately, I have spoken to clients who make a half-assed attempt. I'm just going to call it. So they'll take little Jane, sick of using little Johnny, poor little Johnny. They'll take little Jane to handover and they'll be sitting in the car and mum stays sitting in the car and says to little Jane, "Oh, your dad's over there, off you go." But you don't have to if you don't want, or just not themselves getting out the car, positively encouraging, "Let's go see dad, there's quite a difference. So we do see that a bit, unfortunately, and it's very upsetting to see, but it's also difficult to prove. But as a parent, you need to know that if there's orders in place, the court expects you not to be passive. This is where we see issues come up. If there's old orders that don't provide for reviews and don't account for children getting older and their needs changing, and I also see issues coming up where children have not been able to participate in the first place and have not had any input around the orders made in relation to them and their life. So I mentioned before, I'm a children's lawyer. That's only in matters where the court appoints a children's lawyer. Many matters are finalised without that happening. Many matters are finalised without a family report, so the children don't have a chance to tell the family report writer what their concerns are, what their wishes are. So I think that's one of the issues in itself, is the lack of child participation. I've just said there, this is where the legal advisors should see a typo here. If you can drop it in the chat box. I put the wrong section of the Family Law Act there. And if there's crickets, if there's no answer, then that's a bit concerning from the legal advisors. Kids' views are only one of the factors that are considered when the court makes orders about kids. It's only one of the factors. Court's also going to look at their age, length of time since the final orders were made. The court's going to look at the conduct of parties since the orders were made. So is this resistance of the child a new thing? Is there a reason for it? Has there historically been alienation, for example? These are the things that the court would look at, and it's just really important to remember that every matter is different. So whether you're talking parenting plans or orders, always important to remember that if it's safe to do so, and if you can, first of all, talk to the other parent. I know it's easy for me to say so, particularly in those really difficult matters where you're struggling to communicate with your ex-partner. But consider mediation, consider solicitor-assisted mediation if mediation by yourself has not got you far previously. Get legal advice, definitely. I think that's just really important because every matter is different. I'm just going to pause there. I'm mindful of the time. I've just got 1 minute really to go, a couple minutes if you're able to stick around. And I just want to summarise what we've spoken about today, a few key points here that I've put up on the slide. The importance of drafting. So if you're a family dispute resolution practitioner assisting parents with parenting plans, it's really important that a parenting plan sets out clearly the expectation of parents, and so there's less room for error, less room for arguments, if I can put it that way. Same goes with court orders, consent minutes of order. If you're a legal advisor, or self-represented, the importance of ensuring that it's drafted well, so you've got really clear expectations. The operative order is clear if there ever is a breach. If there are breaches, what outcome are you wanting? Do you want the other parent penalised? Is that the main thing you're wanting? Because if so, the court's probably not going to be too impressed. Okay. Are you wanting enforcement? Is the matter urgent? Do you need a recovery order? Do you want to stay out of court? Is mediation appropriate? You really just need to think through what outcome you're wanting. If you do go to court, make sure you're doing the right application, okay? And finally, I'm always going to advise this because I'm a lawyer, is to get legal advice because every matter is different, and sometimes the delay or filing a wrong application can really impact the outcome. Get the legal advice early. I think I'm all wrapped up. I'm mindful of the time. Thank you for everyone who's stayed on. No one's left yet, which is beautiful. We have dropped the slides. We dropped the handouts. Grab them now if you haven't already. We have dropped an offer. If you want to speak to one of our solicitors by Zoom or phone, drop that offer there already. If you're a service provider and you want to speak with me, just reach out. I'm happy to help. If your organisation would like me to talk to you, I'm happy to do that as well. Otherwise, if it's all right with you guys, I am going to take a sip of tea, and only 2 people have left, so that's good. And I'm going to check the questions. Crikey. All right. This is more than I expected. All right. Joshua, what forms do I need for a recovery order? I think I've covered that. Elena, what is the cost to the client of obtaining a consent minute of order? For parenting matters, you can draft them yourself, but you run the risk of not drafting them well, which is what I've mentioned already. It depends. If you'd like a quote for us to draft it, just send me an email and some details about your particular matter to give me an idea of the complexity. With the parenting plans, Elham, if you can drop the link to our parenting course in the chat again. If you want a well-crafted parenting plan, and I'm biased because I spent a whole day drafting it, you can access that within the parenting after separation course, which is low cost. If any service providers want free access to that, to check it out, just let me know. I'll give you free access. Okay. I'm just looking through the questions. What can I do if one of the parents is using a court order to further control me? Threatening to hang up during phone calls. She threatens to gaslight me. Really difficult. So someone's just asked a question about a lot of what I would call little breaches of order, or smaller breaches of order. What I would do in that circumstance is I would buy a notebook, and I would start writing everything down in chronological order, date, time that these things have happened. Ensure the kids can't see it, because you want to show a persistent ongoing breach or concern around the orders, because if you went with just a couple of those little things, you might get a cost order against you. You want to be able to establish the ongoing, what you say is control and bad conduct. One parent consistently breaches the phone contact reported to the ICL, but there's been no improvements. So firstly, if it's been reported to the ICL about phone breaches, just know that the ICL is not the judge. So we can't make decisions as ICL. If you've got concerns, they need to be put to the court. And that's exactly what I would do. I would put any ongoing concerns in an affidavit material. But first of all, make sure you've noted them all, as I mentioned, because you don't want to be seen as being petty. But likewise, if you've consistently got 2 months worth of every single call is late, then you can put that in the proper format. Question, can you request a change in orders as part of the contravention order to be more specific? I think you mean for the order to be more specific and more clear. What I would say is that if there's a contravention before the court, one of the aims of the person conducting that hearing, the judicial officer, will be to make any changes to the orders anyway to make sure it's crystal clear to the to the parties. So you'll probably find that's a flow-on effect anyway. Question about internet was cutting in and out. Can you put a recording? You'll all get sent a recording, I think. If not, please email. Okay, how old is old enough for the children to make this decision not to go? I hope I've answered that as best as I could. How do you know when it's time to get children involved in decision making? How do you know if they're mature enough? What I would say to that is that if you're going to family dispute resolution, and I'm sure the mediators here will agree, talk it through with them and see what they say, because they're the experts. If they do child inclusive mediation, they're the experts. If your matter's in court, then there might be a children's lawyer, there might not. The judge will help you and guide you around how to ascertain the children's views, and it might be through a family report. Most matters that go through the court have a family report where if the children are old enough, they'll be interviewed and their views will be taken, and that's just one factor that's considered. I've got through most of those questions and only 2 more people have left, so that's good. I will finish up now. If you've got any questions, I'll just put up this last slide with all my details. I got a bit off topic there. All right. There's the squishy me face because my slides didn't work. If you want more from me, just reach out. I'm happy to help. Otherwise, thank you everybody for attending today. We had a record turnout, record registration, which just says to me that this is an area really of concern. I hope I haven't just raised more questions, and I hope I've given you at least some guidance and answers. So have a great day, and we'll chat to you all soon. Okay, bye for now.